Welcome to Stock Trading Everywhere All at Once, Public Servants and Financial Conflicts. I'm Paul Smith, Senior Vice President for the Campaign Legal Center. Thank you all for joining us. Campaign Legal Center, CLC, is a national nonpartisan organization that works to advance democracy through law at the federal, state, and local levels. We fight for every American's right to participate in the democratic process, and we believe our democracy should be transparent, accountable, and inclusive. This year marks the 45th anniversary of the Ethics in Government Act of 1978, the federal law requiring officials in all three branches of the federal government to disclose stock ownership. The law was intended to increase public confidence and trust in government, but unfortunately, that hasn't happened. Instead, the public remains unable to trust that their interests are being prioritized as public officials in Congress, executive branch agencies, and the courts continue trading stocks, even though they're connected to their official duties. This lack of trust, of course, stems from a perceived conflicts of interests, a problem which persists across government. Reporting shows that at least 15 lawmakers, that is, members of Congress overseeing defense policy, are invested in military contractors. Numerous senior officials of at least 4 executive branch agencies traded stock in companies connected to their official duties, and 61 federal judges traded stock of companies that had cases before them. How to address this continued mistrust and what steps must be taken to assure the public that these officials are prioritizing public good over personal financial interest remains an active debate in Washington. But one thing is clear: without a serious response, voters will question whether officials are acting to serve the people or their own wallets. With that, I'd like to turn it over to our moderator for today, CLC's Vice President, General Counsel, and Senior Director for Ethics, Kedrick Payne.
Thank you, Paul. Thank you for that introduction. And now what I will do is introduce our expert panel on this very timely topic. It's very timely because new legislation was just introduced this week to try to address the problem. First, what I will do, though, before introducing the panel, is explain how we will make this more interactive for the audience. If the audience has any questions, please put those in the comments section in your Facebook or your YouTube platform, and we will answer those questions during the question and answer period that will come after the panel discussion. If for any reason we are unable to get to all of the questions, all you have to do is send us an email with those questions and we will answer them. If you are part of the media, you can send that question to media@campaignlegal.org. That's media@campaignlegal.org. Or if you're a member of the public, send it to info@campaignlegal.org. So now let me introduce the panel. First, with our legal experts, I will start with Danielle Caputo. Danielle is an attorney here at Campaign Legal Center. She specializes in Supreme Court ethics, congressional ethics, and policy development. Next is Gabe Lezra. He is federal policy manager at CREW, the Committee for Responsibility and Ethics in Washington. He specializes in democracy reform, government ethics, and anti-corruption. And now I would turn to our, I would say, the Wall Street Journal dream team of investigative reporters. This is the team of 3 reporters who have been involved in in-depth reporting on this stock trading issue in each branch of government. Starting with Rebecca Ballhaus. Rebecca is a Pulitzer Prize winning investigative journalist who is based in New York. Next is Brody Mullins, who is a Wall Street veteran, Wall Street Journal veteran. He has been with the news agency for close to 20 years now, and he is based in Washington, D.C. And finally, Joe Paluzza, who is also a Pulitzer Prize winning investigative journalist who is based in New York. I think it's important, before we begin with this conversation, is just to outline the purpose of why we are here. We want to go beyond the headlines, beyond what the public may already think they know about this issue, to get to the complexity of the problem, to get to the potential solutions, and also to discuss the probability of any real change or any real reform. It is important to just think about how we got to where we are today. It is almost 4 years and, well, 3 years, I should say, 3 years and 1 month to the day that news broke about the stock trading of Senator Burr. And Senator Burr was accused of insider trading because he made trades in stocks immediately before the pandemic hit the United States that seemed to be tied to closed door briefings he had about the severity of the pandemic. And based on that reporting, there was a focus on not only stock trades in the Senate, but also the House. But over the course of the past 3 years, there's been a spotlight on the trading happening at federal agencies as well as the courts. And that is the complexity of the problem that we want to discuss in more detail today. I do think before we talk, I should give a basic description of the law and how it applies across the branches. In the basic terms, first, there's a disclosure law such that all senior officials in the courts, at the agencies, and in the Congress must report their stock ownership in the stock trades. Second, in the courts, there's a recusal requirement, which just means that judges are supposed to recuse from cases where the parties involve companies in which the judges are invested. And finally, in the agencies, there's not only a recusal requirement, but there is a prohibition in some agencies for officials to own certain stocks. So with all of those laws, you would think that maybe there would not be the controversies with stock trading, but as we will discuss now, that is not always the case. So turning to the panel, let's discuss Congress, taking this agency or branch by branch. In Congress, what are we learning and seeing about stock trading now, 3 years after the initial controversy, and what are we hearing from lawmakers regarding the controversy surrounding that activity? And I'll turn to Rebecca. I know that you do quite a lot of work in looking at stock trades.
Yeah, so what's really remarkable to me about this area is that it's gotten so much scrutiny over the years, and yet it really hasn't, lawmakers just haven't stopped doing it. So I started at the Journal 10 years ago as an intern, helping Brody on stories about members of Congress trading stocks in areas that they regulated. And last week I did a story on that exact area on two House lawmakers who were trading bank stocks right in the aftermath of the bank failures last month. And so the most egregious example there was a New York Republican who met with financial regulators about the closure of Signature Bank. And then a couple of days later, buys stock in a New York bank, which soon after that takes over the deposits of Signature Bank, which sends their stock up more than 30%. So it looks like an incredibly well-timed trade. Her office says that she wasn't aware that that was going to happen, that she wasn't trading on inside knowledge. But nonetheless, it's an example of how when you have so many loopholes in the rules, or really a lack of rules at all in this area, there are so many opportunities for trades that look really bad, and you're really relying on the word of these lawmakers that they're not doing something wrong. So I think we've seen, as you mentioned with the Burr trading, what lawmakers tend to do is distance themselves from the trades. They say they have a financial advisor, or that they made the trade at the recommendation of somebody else. But with Burr, I think you even had the SEC saying that he made a call to his broker and directed him to sell stocks in his wife's account in this very sensitive time before COVID hit. So I think we've seen a lot of excuses from lawmakers, but really the behavior has not changed at all.
One of the things that I think is interesting to that end is that for the last 10 years, we have been able to see how these stock trades are being made and when they're being made, because the Stock Act was successful in its attempt to bring transparency to these stock trades. So they're required to say and submit a periodic transaction report that says, oh, we did, I traded this stock within 45 days of trading it. And so we're getting that information, and by and large, overall members are following that law. But what we're seeing now because of that is just how questionable the stock trades that they're making are, and whether or not they are, to the point of insider trading, they still present clear conflicts of interest. And we know that now because of the Stock Act, but it also shows us why the Stock Act doesn't go far enough and is not enough to stop this conflict.
That's very interesting that these members are complying with the law, so we see their trading, but it still doesn't stop the problem of the conflicts. And that makes, I guess, policymakers think, okay, there has to be a way to do more than simply have disclosure. And one thing that is proposed sometimes is to have a recusal where, okay, you just can't work on the topics where you might have an investment. And the courts have such a rule, but what are we seeing for the journalists who cover the courts? What are we seeing with the conflicts and the potential problems with judges who are under a more stricter rule than you see in Congress?
Yeah. So their rule is stricter in that the law says that if you have a financial interest, however small, in a party that's before you, if you're a judge, then you have to recuse. And this also, as with Congress, has been reported on repeatedly over decades now. And the most recent study that we did, the journal did, was in 2021, and we, with the help of a nonprofit, got our hands on all of the disclosure forms for judges, and we were looking at 2010 to 2018, and then we compared them to tens of thousands of court dockets, and what we found, bowled us over. We weren't expecting it. It was 152 federal judges oversaw more than 1,000 cases. It was 1,076 cases involving companies in which their spouses or their dependents held stock. And just a couple of things about those numbers. So first of all, they were almost all trial judges, so they're federal district judges. And we found that 2/3 of them disclosed holdings of individual stocks. So 2/3 of all the judges that we reviewed owned shares of companies, as opposed to just having investments in funds, for instance. And then, so of those judges who had stock, 1 in 5 of them improperly heard at least one case, involving a company that they held stock. And then we also looked at rulings, and we were super conservative in the way that we did our review. So we were only looking at rulings on contested motions, contested substantive motions, so big ones like motions to dismiss. And when we looked at those, we found that 2/3 of those rulings came down in favor of the judge's financial interests. So the findings, we did not expect that we were going to find so many judges who had these conflicts. And to a judge, they said that obviously the interest that they held in these companies did not influence them in any way in their rulings, they said. And they offered a lot of excuses and explanations for why they missed this. So some of them just blamed their court clerks, who they have designated as, they've deputized as kind of their conflict spotters. Some of them said that there were misspellings in their recusal lists. So these are lists that the judges keep on file of all of the the companies in which they have a financial interest, or parties, relationships that would require them to recuse. And so they'd say, oh, I had Exxon on there, but I didn't have this Exxon subsidiary. That's also kind of a lame excuse, because all parties before courts, when the corporations, have to file disclosure statements explaining their corporate parentage for the specifically so that judges can evaluate whether they need to recuse. One judge blamed his wife, who he said filled out his forms. Like Rebecca said, we had other judges who misunderstood the law. They thought that because their accounts were managed by brokers that they did not have to recuse. They sort of equated them incorrectly to mutual funds. So yeah, they really ran the gamut. And yeah, I mean, I think I'll stop there now that we've sort of identified the problem, and there has been some movement on this, and we can talk about that later.
I think one of the things too you see with that is that recusal rules, there are a lot of excuses, but if they're not being enforced, then it doesn't actually incentivize judges to do things properly, because there's not really any recourse for them. Given the sheer volume, especially, you see that the recusal rules aren't clearly being monitored, and whether that is the fault of the clerk or the wife or whomever, at the end of the day, the law is the law, and these judges aren't following it, and they're not really incentivized to follow it because there's no sort of repercussion or anyone who seems to be following up on this besides clearly the Wall Street Journal.
Exactly.
You know, Kendrick, if you don't mind, I'm just to jump in really quickly. You mentioned, and we're talking about recusal here. You mentioned earlier that recusal could be an option for Congress, but the truth is that we do not have a recusal requirement for Congress, because if Congress members recuse, then they're depriving their constituents of their voice being heard on these matters. So these recusal requirements don't make sense in some of these situations, including across Congress and elements of the executive branch we'll talk about next. So not only do we have these recusal requirements not being enforced in many circumstances of the judiciary, we can't allow them to happen in Congress. So these are a pretty limited set of solutions to this problem, and we'll get into that in a second.
That's a very good point, Gabe, that the recusal option wouldn't even work in Congress. So, and we see the disclosure isn't working. So the next option would be just to prohibit members from owning any stock. But let's talk about where a similar restriction exists, and that's with the federal agencies. There are some agencies that not only require the senior officials to recuse from matters related to their financial interests, but also just ban the ownership of stock that is regulated by the agency. Again, let me turn to the fact finders, the journalists. What are you seeing in the executive branch with agencies that have requirements that should restrict the ownership of stocks that conflict with official duties?
So I can answer that question, but let me just roll back for 1 minute. 10 years ago, or maybe 12 years ago, when Rebecca and I first started writing about stock holding in Congress, there was not only no law, but people thought that the insider trading laws did not apply to Congress. The Stock Act, for its flaws, did a couple of good things. One thing that it said, and this sounds crazy, but it said it's illegal to trade stocks and inside information. And that was like a new thing somehow in Congress. So that does exist now. Also, there's more disclosure that there was not before. So there has been some progress. What was interesting to Rebecca and I when we first started on this project of looking at stock trading in the executive branch is we said, okay, in Congress, there's no rules and it's a free-for-all. But in the executive branch, there looks like there's pretty clear rules that say you cannot own a stock or trade a stock in a company in which you have a conflict. So we gathered all these forms, financial disclosure and trading forms from executive branch employees, and we thought, we probably won't find anything here. And then we started looking at them, and we were blown away at a place where there seemed to be very clear rules. You cannot do this. Everyone was doing it. So that the question then goes to enforcement, implementation. Who's following these rules? And I think the case with the executive branch is that these rules have been in place for so long, and these forms have been out there for so long that people just didn't really look at them anymore, or really. Since there had been so little enforcement, in fact, almost no enforcement, employees, people started doing whatever they wanted to do. So when we came along, we found tons of violations because even though the rule existed, everyone ignored it.
And then what was the result once you found these violations? Did anything happen once they were revealed?
Well, as you know, everything in Washington works slowly. What we're trying to figure out right now is, what is the result? And it seems like there's some growing momentum, perhaps, for new laws being passed to do something. It seems like every few weeks or so, there's a new piece of legislation, there's a new investigation, there's a new report that comes out calling for tighter rules. We're far from a consensus on what those rules should be. So we'll see. But I think there's legislation out very recently that says that each executive branch should craft their own new rules for their own agency. But again, we're far from that happening. Another point to make, as you know, nothing happens in Washington on the ethics front unless there's a scandal. So the question is this a scandal? Are we in a scandal period, or does something bigger need to happen?
Mm-hmm. Mm-hmm.
Just to add to that, if I can, one thing that was really striking, I think, when we looked through, how the ethics offices in each of these agencies handle conflict, is that there really are very few consequences, even when they do find a conflict of interest. So for a couple of the conflicts that we flagged, they referred the matter to the Inspector General. We haven't heard of anything coming out of any of those probes yet. But there were a couple instances where we found a conflict that the agency had already identified. And even in those instances, you saw really very little happening. I think one official who owned stock in something that was a clear conflict got additional training as punishment for owning that stock. And there were a couple other instances where, there was a CFTC official who was allowed to trade or was allowed to report around 3,000 trades that violated the agency's rules because the agency was worried that if they enforced the rules, they could be sued. So I think the lack of consequences internally was a really astounding part of this reporting.
Yeah, and two other points. You had asked earlier about, you had mentioned some agencies have strict rules that say you cannot own particular stocks. Joe found someone who owned a ton of stocks on the list of stocks that you can't own.
And nothing happened, right?
Yeah, and Brody's talking about it pretty clear. This is an FDA case, right? So if you're a senior official in the FDA, you shouldn't own pharmaceutical stocks, right? I mean, this is, but this person did, and what essentially happened is when the FDA realized that he had all of these prohibited interests, they said, well, you can sell them off and just remain here, or you can leave. And this official decided that he was close to retirement, and he just decided to leave instead of remain, even though remaining, the only consequences to him would have been sort of financial.
So there's so many stories here that we ran into that would be really hilarious if they weren't so sad. And one of them is about the rules themselves. The employees of the federal government are obliged to follow the rules of the agency while they work there, as in the agency has jurisdiction and control to punish an employee, but once the employee leaves, they can't do anything. So we found a number of people who were basically caught and said, I guess I'll just quit. And as soon as you quit, you're off the hook.
Right. And which is, all this is really interesting, because actually the executive branch is subject to is the only branch that's subject to the criminal conflict of interest statute. So that should be a deterrent for some of this behavior. The problem is that statute is unbelievably complicated and esoteric, and the way it's been interpreted is to allow a lot of this behavior, and it really is just about members or people in the branch participating in extremely specific circumstances with extremely specific financial interests. So the way that the statute was written and the way that the statute has been interpreted has allowed for all of this stuff to happen. So there should be at least some effort to at least improve that criminal conflict statute if we really want to create a sufficient deterrent for this behavior.
So let's talk about that now, improvements. All right. So we've talked about the problem, which seems just almost insurmountable. When you think about in Congress, there's only the disclosure requirement, but when the members comply with that, they still have all of these obvious conflicts. When we have the recusal requirement in courts, it's not being enforced. And even when you have the stronger laws in the executive branch, when there is enforcement, meaning there's an investigation by the IG, nothing seems to come of it. So let's take it one by one, because Gabe, you pointed out that each branch may have different options that are even possible. When it comes to the legislative branch with Congress, what are the options for reform that could really make a difference?
Yeah. So yeah, exactly. These places, these branches do have different kind of esoteric issues that need to be addressed, and the ways that those can be addressed really are going to be different based on those options, right? And I'll just say before I jump into the legislative branch, with respect to the executive branch, there is this issue, right, which is that in general, employees of the executive branch, especially like politicals, only serve for a couple years. So when you compare that to the terms of office for people in Congress or lifetime terms for people in the federal judiciary, it really does require a little bit of a lighter touch, I think, just to make it fair. You go into public service and you don't want to have to, and you have to serve the public, and that's absolutely true. But in the executive branch, it is worth at least thinking through whether we want to impose as harsh a structure as we do in Congress and the judiciary. Okay, so speaking of Congress, we at Crew have been working for years now to try to improve this system after the Stock Act, and we've discussed why that hasn't been working. The best option, and the option that we're now seeing from members as they introduce bills, is full divestment, right? Requiring members of Congress to divest any individual holdings, because any individual holdings will create conflict concerns, regardless of whether the member is even acting on those or voting on those specifically, or even if the member doesn't even know about it. The point is that the public will see that and will think that the member is doing these things based on it. So we and most of the kind of public interest in public sector, including Republicans, including conservative groups, are encouraging and have helped design bills that fully ban members of Congress from owning and trading stocks. So it's not just about prohibiting insider trading like in the Burr case. It's also about prohibiting members from owning, as these wonderful investigative reporters have shown they do, stocks and companies that they regulate, because that actually creates the larger conflict concern. So as you mentioned earlier, we've seen just this week or just 2 days ago, Senate Democrats introduced a fantastic package of reforms called the Ethics Act with about almost half the caucus on it. And that bill would ban members of Congress from owning and trading stocks. It would impose pretty harsh penalties on those members if they violated it. And they would also extend the prohibitions to members' spouses and dependent children, because if members' spouses own these stocks, functionally it's the same thing. And it's the same basic idea for dependent children, even if those are in trust structures. They include a number of exceptions, right? This isn't asking members or anyone to take a vow of poverty, right? They can invest their stock in things that don't create conflicts, like investment in index funds, right? Which is just an investment in the market, investment in IRAs, investment in things that just, you can, when you look at them, you can't actually act on them in any way that would be specific or whatever, right? And most Americans do invest that way. Like everyone has investments in some way in the stock market. And all we're asking is that members of Congress invest their money in the way that we invest ours. And I'll just say also, these reforms are wildly popular. We're seeing numbers beyond anything most, that we get almost ever, right? It's 70+% across the board, Republicans, Independents, and Democrats. So these are things that the public desperately wants and the public desperately deserves.
All right, thank you, Gabe. That solution does sound like something that would close the gaps that we've talked about across the three branches. At least it could do it within Congress, which is you don't have to worry about whether someone recuses. You don't have to worry about whether there is a conflict, and you don't have to worry about determining if anyone owns a particular stock that could be a conflict, because they own nothing. Everything is fully divested unless it's in a blind trust. The next part we should discuss, though, is that may not work for the other branches. So what would happen in the judiciary and with the executive branch if you impose those same type of divestment requirements? Like, what are the real options for the other two branches? And I'll turn that over to Danielle.
Sure. To Gabe's earlier point, this isn't a question of, one size fits all approach. There are different considerations to take when it comes to the judicial branch versus the executive branch versus the legislative. And so Gabe did a great job kind of laying out what the best case scenario and option is for the legislative branch. But the best options for both the executive and judicial branch are, first of all, just better enforcement. They both of these branches have laws on the books that, if properly enforced, would do a good job of kind of getting rid of or eliminating or enforcing and stopping these sorts of conflicts that we're seeing here. So in the executive branch, the rules are good, but ethics officials aren't actually requiring, people who are working in the executive branch and these officials to make sure that they don't have conflicts. They're supposed to make sure that there's not even an appearance of a conflict, whether or not it's an actual conflict itself. And as we've seen in this reporting and in the complaints that, Campaign Legal Center has filed, we're seeing that there are the appearance of a conflict at the very least. And ethics officials are still okaying these sorts of financial interests and trades. If they were to stop doing that, then that in and of itself would be a great first step in limiting the sort of conflicts that we see. In the judicial branch, we've had a little bit of movement. Part of the problem that when this was first uncovered by Joe back in 2021 is that it was very hard for litigants to get the financial disclosure reports from the judges, and they didn't know what holdings they had. And that's a problem. That's a problem that we don't see in the executive branch and the legislative branch, because they have to publicly report whatever holdings they have. So Congress last year did update that, and now the judicial branch is subject to the same thing. But what you see is that obviously transparency and disclosure alone is not necessarily going to be enough. So what we need is for the judicial branch to actually enforce these rules. And it's honestly pretty simple. Part of what Joe was saying earlier about Exxon getting missed in a case was because the party had the word oil in it, but in the judge's list of his holdings, he just said ExxonMobil or something of that nature. And just because the automatic procedures that they have that check any sort of conflicts, there was like a single word that was different, and there had been instances of maybe something being misspelled. You can create a better automatic system to check for those sorts of conflicts, and maybe have a person go through and see, okay, this says ExxonMobil and this says ExxonMobil Oil or whatever it is, and see that those are actually the same things and it's a subsidiary or something. So those are really the best ways to at least start getting at the problem from where we are now in the executive and judicial branch.
And I'll just add also that divestment would work. Of course it would in these circumstances, right? Requiring that federal judges divest all their holdings and not own individual stocks seems like a no-brainer as well. It's certainly something that's been talked about, So it's not just that, this wouldn't, work across the branches. It would. It's just the question of whether we want to, impose such an intense and comprehensive requirement there, especially in circumstances where recusal is an option. But it would work. It's not like that. It does cure all of these conflicts concerns.
And one thing I would add to that we heard from a lot of readers when our stories came out is, I take the point about political appointees who entered the executive branch just for a few years, although there are also, of course, career officials who are there for decades. But we heard from all kinds of readers who were pretty outraged because they were like, I had to get rid of all my stocks when I entered this private company. I can't believe that people who are working for the government have laxer restrictions than I do. So I do think that that's an area that tends to elicit a lot of anger from people who have followed the rules. And I would also just note that we did encounter a lot of executive branch officials who did sell all their stocks out of sort of an abundance of caution and said they wanted to avoid even the appearance of anything bad. So I think some of them also were not that thrilled to learn that they're the only ones.
Brody, did you have anything to add?
I was just going to add one thing, which is that as reporters, we can easily lose our jobs by advocating for what the solution is. So we're not going to go there. But as reporters, we also would always advocate for disclosure. Congress does have a very good disclosure system. If you're, if you live in Missouri District 2, you can find out in 30 seconds what your member of Congress owns and what they're trading. On the executive branch, that's not true. We spent about a year on this project of looking at stock trading by executive branch officials. Maybe a third of that time was just trying to get the forms. I mean, there are government agencies we contacted more than a year ago who still have not turned over the stock trading forms of their employees, documents which are considered public. So perhaps having a better disclosure system so that reporters, the public, bosses, whomever can look at these supposedly public forms, maybe that could help cleanse the system somewhat.
Let me ask one more question to the panel on the same theme before we turn to the audience. But the journalists, what are you hearing from lawmakers on what reforms or what change they would be open to? And I ask that question because we can sit here and discuss what the problem is and talk about from an academic perspective what the right solution would be. But if the public pressure and the comments from readers is not making any difference with the lawmakers and their appetite for change, all of this may be for naught. So what are you hearing from lawmakers?
I mean, we've gotten pretty bipartisan reactions from lawmakers that this is an area that they think needs to be improved. You had Elizabeth Warren sent out letters to several agencies asking them to review what their ethics offices were doing. Josh Hawley introduced a bill saying that, we should ban stock ownership in the executive branch. There have been a number of other bills that have been introduced, but they're really don't seem to be getting much traction so far. So I don't think we've necessarily seen that change. There seemed to be a brief moment in the fall where maybe something was going to happen with House Democrats' proposal, which would have banned stock ownership or required lawmakers and executive branch officials to put their stocks into blind trusts. But that stalled out. And I don't think we've really seen a moment since then where it seemed like we were on the cusp of something actually happening. So it's been sort of slow going on that front.
All right. I think now we can turn it to the audience if we have any questions from them.
I can grab that one if you'd like. Thanks, Barbara, for the question. No, these were not, so judges can be invested in mutual funds, and that doesn't trigger recusal. They don't have to list all of the component companies, or with a fund, you're not actually directly invested in the company. You're invested in the fund, which is invested in the company. So there's that layer there, which is why the law makes it okay for you to be invested in mutual funds. Now, these were judges who outright they or their families owned a share of a company that was appearing before them. The most common ones were the biggest companies.
And just to build on that for a second, mutual funds are what most Americans own. Diversified, mutual funds, and those just don't present conflict concerns because A, you don't really know what's in them, and B, there's so many different interests within the mutual fund that you can't really know if you make one decision whether it would benefit the fund more than a different decision. So that's why mutual funds are generally considered non-conflicting interests, especially diversified funds. Now, there are questions about sector funds, like if a fund invests in the tech sector, that's a little bit more complicated, but in general, mutual funds are considered non-conflicting investments across the three branches.
All right, thank you for that question, Barbara. We'll see if there are any more. Danielle, can you take that one about who's responsible for enforcement in each of the branches?
Sure. So generally speaking, the ethics office for each branch. So you have, the committees, ethics committees in the Senate and in the House, and then you have, I guess, a few layers in the executive branch. First, you have the designated agency ethics official, you have the inspector general, and then you have the Office of Government Ethics, which is kind of like the agency that oversees all of that and deals with enforcement there. And then you have the judicial conference in the judicial branch. And then depending on I guess, certain instances, and depending on, I guess, what law is violated, it can go up to the DOJ.
Thank
And
you.
I would just add that in the judicial branch, it's also, there is obviously litigants can enforce the law. They can move judges to recuse themselves if they find out about a conflict. So the judicial conference has not done anything, has never disciplined a judge. There's been no public discipline of a judge for hearing a case involving a company in which he or she was invested that we know of. And no judge has been impeached for that course of conduct. But when litigants find out about it, they can actually have a judge removed from their case. Though I'm sorry to go on, but a problem there is that often it's the judge who has the conflict that's ruling on that motion about whether to remove the judge. So it's also kind of a fraught process.
Well, so we did, this was in one of our first stories about this. We looked at officials at state and DOD who owned stock in Alibaba at the time that they were discussing adding the company to a blacklist of companies in which Americans couldn't own stock. And it was, I thought, a pretty interesting example because you had an official who acknowledged being in conversations about the blacklist, who bought and then sold Alibaba at a sort of helpful two pretty well-timed points. I think he didn't make a ton of money. It was something like $1,500. But we brought that to DOD, and they basically said because he wasn't in charge of the final determination of which companies would be on that blacklist, that there wasn't an issue. So I think it's another example of how narrowly those rules tend to be enforced, where if you're not in charge of something, you can trade even if you're a part of conversations about it.
On a related area, we found executive branch employees who were shorting stocks and shorting the market, which is perfectly legal. It means that you're betting that the stock of a company is going to go down, or if you're betting on an index fund, you're betting that the stock market will go down, which again is totally fine. But it just seemed to me that if you're an employee of the U.S. government, there's something wrong in betting that the whole market's going to crash, which is something that you can kind of affect. It seemed sort of unpatriotic to me, but perfectly legal.
And this is exactly why the general belief and the general solution that most advocates believe is that we should prohibit individual stock ownership across all three branches of government. It is a thing that you can do, a thing that's doable, and it is the thing that fixes this problem entirely. This would not have an issue. You wouldn't have issues with these kind of upsetting instances of governments, people in the government owning stock and companies that are owned by people, countries that are potentially engaging in bad actions against the U.S. government. Divestment and then prohibition is a good solution across the government. And as Rebecca mentioned earlier, that's true in the executive branch too, even though we have some of these rules, like they really shouldn't be owning stock either. And that's generally the position of Crew and most advocates.
Let's take one more question.
Yeah, I can take this one. So yeah, this is an important point. In general, these proposals would prohibit investments in PE or VC and this type of investment as well. These just don't really have a distinction between publicly traded stocks, right? These proposals would ban stocks, bonds, commodities, cryptocurrencies, or any investment that resembles that type of thing as a financial instrument, investment even in individual companies. And I'll just mention also that, especially in the legislative branch, this was a question earlier in this process, which involved questions about whether we should accept ownership in people's, say, individual farms or ownership in companies. And so what some of the proposals, and I believe Senator Warren's bipartisan ban on congressional stock ownership does, is accept small interest in small businesses that fall under the small business definition in the SBA. But that is a question that's still open. But I think that should, most of these proposals would ban any type of investment, like all of those things. But that is really one of the sticking and open questions across as we move forward with these various proposals.
All right. Well, we thank the audience for all of their questions. I did want to leave a moment for everyone on the panel to give closing remarks. I do think overall what we've been able to discuss today is extremely important and timely, as I mentioned, because a lot of times the focus is only on congressional stock trading, and the problem is much bigger than that. And the potential solutions have pros and cons that have to be weighed so that the ultimate outcome is not a worse situation than what we currently have. I do want to start with closing remarks with Joe.
Thanks, Kedrick. So there was a law that was passed in response to our reporting, the Courthouse Ethics and Transparency Act that Danielle mentioned. And again, it pretty much brought the judiciary in line with the Stock Act with Congress. So they have to have a publicly accessible database of these forms, and they have to file transaction reports soon after they make trades. So, that process, exactly a year ago today was when that, or almost exactly a year ago today is when that passed. So the database is up and running. But, if you went to it right now, the most recent annual financial disclosure forms you'd be able to get your hands on are 2021. So, there's still some sort of work to be done there, and speed, because if you're a litigant, you need to know what the judge is holding now, not what he was or she was holding 2 years ago. And then, as I mentioned before, that you have this situation where when the litigants do try and get a judge to recuse because he or she has a financial interest, that judge is the one who's ruling on that motion. I think it would be a pretty easy fix. It's been suggested that the chief judge of that district, may be someone who could weigh in instead of the judge to remove the conflict of the conflict. I think. Yeah, I'm gonna end it there. I think there's been some really, really great progress, and I think the judiciary does deserve some time to figure this out and get this database up and running. But as far as just to piggyback on what Brody said, more transparency is good, and that's what we want, and certainly we've been moving in that direction, which is good.
Okay, Rebecca.
Yeah, I don't know that I have too much more to add. I think the main point is what Gabe said earlier about how subjective some of these rules are. And I think that's just an area where more clarity in how these rules are written, even at individual agencies where, as Brody was saying, you have a ban on certain kinds of stock ownership. I was just looking back at a story Brody and I did that mentioned the FCC, which bans officials from owning stock in companies that are significantly regulated by the agency, but it doesn't really lay out which companies those are. And so as a result, officials are allowed to own hundreds of thousands of dollars in Google stock because Google's not considered significantly regulated, even though it's often lobbying the FCC for policy changes. So that's, I think, an example of how having a little bit of a more clearly written rule would make the rules easier to enforce and make it clearer to officials what they can and cannot have. Because I think right now you're having a lot of instances where officials are checking their stock holdings with agency ethics officials and are being told they're fine, only to have a reporter call them a couple months later and say, this looks kind of weird.
Mm-hmm. Brody?
So I have the last point. That means I guess I gotta go big on this one. So last night, my wife and I had friends in from out of town, a couple from Boston, and the husband was asking me what I have been working on, and I mentioned, this stock trading stuff in government, and he said, "Doesn't everyone know that everyone in Congress in Washington is insider trading? Like this was like everyone just knows that this is how Washington works. And it struck me as like so sad that that's what people think. And it just seems like for faith in government, for trust in government, which is the most important thing to do anything, if you're Republican or Democrat, independent, it doesn't matter. If people don't trust their government, we're screwed. And this seems like a good place to start.
Yes, yes, I agree with that completely. One of the best examples is the reporting about TikTok accounts that follow the investments of members of Congress because they assume that they must be insider trading. And even if they were not doing insider trading, they then become market movers in and of themselves. Whatever they invest in will go up because people are following it. And that is definitely a problem. Brody, you went big, but we still have two more people to give final remarks. Let's go with Gabe.
Yeah, thank you. And I just before I say anything, I just want to say thank you to to Joe, Brody, and Rebecca. Your work has been phenomenal in this area, and the revelations about the judicial stock trading were shocking to every lawyer that I know. We've been dealing with that. And the fallout of that investigation just in the legal community for now almost a year or two. And it's just been amazing to watch people suddenly come on to the belief of in these sort of judicial ethics and other reforms. And Brody, I just want to say also, I completely agree. This is about faith in our government. And right now we're in a crisis of public confidence. And we've seen the huge drops in public faith in our institutions, in particular in the Supreme Court, which we can get into for other reasons. And these are institutions that only function if public believes in them, especially in the courts. They don't have the ability to enforce their laws. They don't have the power of the purse. They don't have anything other than public confidence. And if that falls away, the entire institution is in trouble. So we're in a desperate position right now. And it's not just that we have these crises in like with respect to our elections and all these things. It's also crisis in our institutions. And in our view, in my view, the only way to really deal with this is to come in with serious and needed and necessary but comprehensive reforms. And I'll just say, I think there is a path in Congress for potential congressional stock trading legislation. We've been working with members on both sides of the aisle. The only thing, though, that is going to make that happen is pressure on leadership. And if you're watching this, please call your senator, call your representative, and tell them that you care about this issue, because I'm sure you do. And that's the only way that this is going to happen. We have a huge number of people who are saying the right stuff, but we have to make them actually do the right thing. And that is going to depend not just on us in the policy community and experts and advocates and journalists in uncovering these scandals. It's going to require public action as well. So I'll just leave it at that.
Thank you, Gabe. And finally, Danielle.
To echo, I guess, both Brody and Gabe, it really is critical for public trust in our democratic institutions that people believe that their officials are acting in the public's best interest and not their own personal financial interest. And whether or not that is the case, it doesn't feel to be the case. And in this instance, perception is reality. And so people are not trusting in what the government is doing and what they're saying because they think it's for their own personal interests. But to also echo, I guess, Gabe as well, there is hope. We have been seeing more movement on these sorts of issues in the last few years than we had really seen since the Stock Act had passed in 2012. So there is an opportunity. There does seem to be movement on both sides of the aisle. There's been pretty strong expressions of support, at least on the congressional side, for passing some sort of legislation that prohibits stock trading to really make sure that the public interest is what comes first. And so I think the momentum is with us. The reporting is kind of the spine and the backbone of this advocacy work, as well as having people then speak up in caring and support of doing something about this. And I think that we are kind of getting to that ledge before we get to the point where change will actually happen. So I'm glad that we were able to have a small part in that and having this conversation with everyone today.
Yes, 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 I agree. And it's right to end on a hopeful note. So I want to thank the panelists again, thanking Danielle, Gabe, Joe, Brody, and Rebecca. And for those who were unable to get their questions answered during our panel this time, you can send that to us via email at info@campaignlegal.org. Thank you again.